to play a game today. And the way it's going to work is Shane is going to read us a fact pattern from a real constitutional law case that is incredibly dumb. And then Professor Chinn and I, who have not read the fact patterns or the cases, are going to guess whether the incredibly dumb argument prevailed before the court. Are you ready?
I'm ready.
So this first case is from 2018, and it's actually a Supreme Court case. Police responded to a noise complaint around 1 a.m. about a party in a vacant house. When the police knocked on the front door, a man looked out the window and then ran upstairs. The police went to the living room where there was a makeshift strip club set up, and women were dancing with cash tucked in their garter belts. Upstairs, the police found several people naked. When the police questioned the partygoers, they told the police conflicting stories, but a couple of people said that a woman named Peaches was renting the house and had given them permission to be there. The police got Peaches on the phone, and Peaches told the police she was renting the house and had given permission to have the party. And police eventually talked to the owner of the house, who said he had not given Peaches or anyone else permission to be in the house. And the police arrested 21 people for unlawful entry. And the partygoers sued for false arrest under the Fourth Amendment and claimed they had permission to be in the house from Peaches.
I don't remember even the barest basics of Fourth Amendment law.
The typical common law classes, we don't cover, constitutional criminal procedure. So I'm going to say they won. I'm going to guess they won.
All right, what's the answer, Shane?
So the partygoers actually lost. The Supreme Court found that the police had probable cause to arrest them because of all of the crazy circumstances. And the court also held that a bona fide belief of a right to enter the house does not defeat probable cause. Public high school banned students from wearing a bracelet that said, "I heart boobies, keep abreast," for breast cancer awareness. So the school said the bracelet was inappropriate and the message was solicitous, profane, and obscene. The school believed the bracelet was offensive to women and inappropriate for school wear, and they confiscated bracelets when students wore them to school. A high school girl received a bracelet like this from her mother, who is a breast cancer survivor, and she wore it to school after the school had already banned the bracelets. She wore it for 3 months at school before a school administrator confiscated it. The student sued, seeking a permanent injunction against the school. She argued that the bracelet promotes a positive breast cancer awareness message, and the school's ban violated her First Amendment free speech protection.
I could see this going either way. I could see the First Amendment argument winning. I could also see the argument for, defaulting to the school's authority to sort of govern appropriate student conduct and behavior or something.
I feel like this is getting back flashbacks to those Fourth Amendment cases involving searches of school lockers, which again, I was like, I don't understand how this works. Even though this is a First Amendment case, I mean.
I'm just gonna go with the school one.
I'm gonna flip a coin. Hold on, let me find a coin. I don't have a coin. Okay, I'm going to guess the school lost.
The school won. The court found that the school's interpretation of the bracelet as vulgar was reasonable. They said that the phrase, "I love boobies," may be lewd or vulgar because of the high school boys' low maturity level and that the bracelet was used as a sexual innuendo. And this was actually really interesting because the Third Circuit, at the exact same time as this Indiana State case, ruled on the exact same bracelet and the opposite way, that it was could not reasonably be deemed as vulgar, and so students could wear it.
Okay, so it's like you were right, it did go either way.
Yeah, close call.
There was a voter-initiated County of Los Angeles Safer Sex in the Adult Film Industry Act that required adult film performers to wear a condom. The plaintiffs were adult filmmakers, and they argued that the condom requirement was a prior restraint on their ability to create expression in the form of adult films, and they argued that they intended to convey particular messages in their films by depicting condomless sex.
I think like a public health consideration versus a free speech consideration. I'm going to guess the public health consideration won and they lost.
Yeah, me too. I mean, it's like the whole like wearing a mask like prevents me from
Right.
exercising my First Amendment right. No.
They lost. So the court found that that they applied intermediate scrutiny and found that there was only a de minimis effect on expression, and that the condomless sex is not a relevant expression for First Amendment purposes. There were 4 elementary school students in Plano, Texas. They said that their religious beliefs require them to introduce their classmates to Christianity. So one 3rd grade boy tried to hand out candy cane ink pens with a laminated bookmark. The bookmark told a story about how the maker of the candy cane created the candy cane as a tribute to Jesus. The school principal told the student not to distribute the pens and bookmark at the winter break party, but the student's parents brought them anyways. And then another student, a 2nd grade girl, tried to give her classmates tickets to a passion play that depicted the crucifixion of Jesus Christ. The principal told the girl's teacher to stop distributing the tickets and to collect the ones that the girl had handed out already. The same 2nd grade girl's mother brought brownies and pencils to school to hand out. Some of the pencils had religious messages on them, and the principal told the mother she could not hand out those specific pencils in school during school hours. And so the students and their parents sued, alleging that they were discriminated against based solely on the basis of religious viewpoint in violation of the First Amendment.
So to clarify, there were things that were preventing them from distributing. Was it like, could other people bring in pencils and brownies? It was just these people that were prevented because of the substance of what they were saying? Or were there sort of like content neutral regulations?
No, so it was pretty, so like the goodie bags at the winter break party, a lot of students brought those to hand out. And so the school said, like, you can still hand out the candy cane ink pens, but you can't hand out the bookmark. And then the parents kind of made a big fit about it. And then the school said, okay, nobody can hand out any goodie bags.
I feel this is a very context sensitive thing, or at least that's my guess would be. Shane, is this another one where there was a mixed ruling?
Hey, don't cheat.
All right. If I have to just do a simple guess, I mean, to the extent that it sounds like the parents have a claim that they're being treated differently because of the religious content of their message, I think they would win.
So this is actually slightly a trick question. The court held that the First Amendment does protect all students from viewpoint discrimination, but that the elementary school principals were granted qualified immunity.
Liz, I'm going to say that we got this one. I want to count this as a win. I don't know. On the substantive question anyway. Did you all have the experience in high school of, like you couldn't like put a poster up on the hallway or flyers or anything like that?
My senior year, we tried to, like every year, the seniors created senior T-shirts that all the seniors wore, and we paid for them ourselves. And but ours said like seniors 2010, and on the back it said respect your elders. And the school banned us from wearing those because they said that respect your elders was hazing.
Yeah.
What about you? What about your school?
It was the last day of class. People would just like dump their papers and binders all over the hallways. It was a celebration to the end of the year. I look back and think it's just wildly irresponsible. But literally, you would like be going up the stairs and see papers like just raining down. People just tossing their binders. It was just a mess that the janitorial staff had to clean up the last day of class. But it was a whole tradition.
That should violate the Constitution.
Probably no legal implications to it, but it just struck me as very like entitled, spoiled behavior on the part of a bunch of snotty, high school students.
I thought that was something that only happened in movies. Like I didn't know students actually did that.
Maybe it speaks to how old I am. I don't know.
you.